right, well, let's jump into it. So, just want to introduce myself real quick. My name's Mike Bernier. I'm a certified financial planner and senior wealth advisor here at Canter Wealth. And just some quick background. Canter Wealth, we offer comprehensive financial planning and asset management. And really, the main focus of what we do on a daily basis is to try to integrate all areas of someone's financial life, whether it's real estate planning, business planning, retirement income planning, tax planning, looking at, of course, investment management and insurance, but then also estate planning. So that's the big focus of, or that is the focus of today's webcast or webinar. And we've been trying to do more and more of these over the last several months, especially as we're in more of a virtual world. Just on different topics, have different guests to, just try to get some good information and education out there. And today, I'm lucky to be joined by Adam Slonim. We were just talking a little while ago before this started, and I've known and worked with Adam for, I guess, the last 16 years now. We were looking back, or he had looked back, and we started working together in 2004, and he's helped a lot of my clients, build their estate plan and helping them, draft those documents. But Adam, glad you're here.
Thanks, Mike. Glad to be here today. Appreciate it. For everyone, my name's Adam Slonim. I'm an estate planning and probate attorney. I've been in business for 20 years now, and I work with everyone from young families to retirees, business executives, people with stock options and RSUs, people who invest in real estate, really anybody who needs help with their estate planning. We're going to talk about why a person would need that in a little bit here, and in particular, how is it different now that we're in the middle of a pandemic?
Yeah, absolutely. And I think, before I forget, before we jump into it, there is a chat button. So, what I know, some of you might have some questions, and so feel free at least the bottom of my screen, or maybe it might be at the top of your screen, but there's a little chat with a bubble. If you want to click on that at any point during the webcast and, type in a question, I'll help, keep track of those. We'll probably save, most of those for the end, unless, I happen to glance at it and it makes sense, right with what we're talking about at that point. But yeah, by all means, feel free to, type in any question that you might have. Estate planning, I'm sure Adam would agree, it's probably a difficult one to just, off the cuff answer. There's a lot of, ins and outs and things to be aware of. So, it might be difficult to answer all questions, but, also as a follow-up, if it makes sense to reach out to myself or reach out to Adam, with any questions, then, we could always, dig a little deeper. So, one thing, and I guess not to put you on the spot, Adam, but I was just curious. So I guess I will put you on the spot. What got you into estate planning? Anything in particular?
Yeah, it's a good question, Mike. I kind of like puzzles. I like to figure out how everything goes together. So when you look at estate planning in terms of the different areas that you could work on in the law, estate planning is kind of the cross section. It's a borderline between so many different things. We deal with property rights and contract rights. We deal with rights between spouses. What happens when somebody passes away? What happens when somebody's incapacitated? Maybe people have property that crosses state lines. So all of these things, all of these moving parts have to be put together in a way that works best for the family to ensure that, and we'll get into this in a moment, but in case of incapacity or after death, who's going to help take care of the kids? Who's going to manage the healthcare? Who's going to manage the finances? And so try to put all those moving parts together in a way that works for people. And that really drew me to the work to be able to help people with that. And if I could say one other thing, there's so many parts in the law where what's happened is that people are already unhappy with each other and they're fighting with each other. And that is a large part of the law. You think of a lawyer, you think of the court and lawsuits. One of my goals when I started in this area was to try to go upstream really and help people to arrange things in advance so they would never end up in that situation. So it's the planning aspect, the looking forward and arranging things so that people don't end up in court is one of the goals for me.
Yeah, and then I'm gonna pull this up and we'll jump into it. But yeah, it's kind of interesting where you're an attorney that helps people, to avoid a lot of attorney fees in a lot of cases, right?
Yeah, well, that's true.
I think
did I just lose video, Mike?
No, I just pulled it up. No, you should still be good.
Okay, yeah, I've heard it said that you never want to be interesting to a doctor and you never want to be interesting to a lawyer. So if you are, that's probably where you would start generating those fees. But yes, you're entirely right, because one of the things we'll look at is if you don't have a plan in place and you have to go through the courts, the amount of time and effort and money that you would have to expend or your family would have to expend will increase by 10x, really, 1,000% increase.
Sure.
So
No, absolutely. Well, let's just touch on, and I'm going to, then let you obviously run with a lot of this, but, just to kind of give everyone a brief, synopsis of what we're going to dig into, it's just going into, I guess, estate planning in a normal world. Normal is always a tough word to use, what's normal, but, we'll get into, with a lot of the changes and, especially through the pandemic, some adjustments that may or may not make sense, but, we'll get into, of the 3-step process when it comes to estate planning. We'll talk documents, we'll talk, trust funding, and as Adam is always referred to it, leave a map and not a mess. So maybe Adam, like in a normal world, or just, I guess the way that I would look at this is, in normal circumstances, why do people need estate planning, or what, type of estate planning is needed?
it's a really good question. And I think most people feel like they know it's something they're supposed to do and they should get around to it. It's not urgent. We all feel like we're going to live forever. But it's so simple, really, at its core, what we do in estate planning, that it might just pass you by. If you stop and think about, what is it that I'm responsible for as a parent and as an adult in this world? It's the kids, it's finances, it's healthcare. And if you think about how you manage those things, it's with a signature, right? You sign the kids up for school, you sign forms at the doctor's office, you sign forms at the bank or at your financial planner's office. And so right now, if you're alive and you have mental capacity, which should be everybody here who's on the Zoom feed today, you don't really need an estate plan in this moment. But in the future, if any of us become incapacitated or after death, we can't sign our names anymore. And if we can't sign our names, then how are we supposed to manage our kids' healthcare and finances? And that's where the estate plan comes in. It's really having access to somebody who can sign on your behalf. So you get to choose who's going to raise and love the kids, who's going to manage my finances, who's going to handle my healthcare for me. And then you give them the power to act on your behalf. You give them instructions for what to do. And we want to set that up in a way that avoids ever having to go to the court and keeps more money with your family and less for Uncle Sam.
Absolutely. Yeah. And I think like you had said, it's just while someone's of sound mind, it's just getting all of that documented. And I know, no one really, I mean, it's just like looking at like life insurance or, long-term care needs, estate planning is not, no offense, something that's super exciting. Somebody's, really looking forward to. And, I think we all, think, oh, that's, something I'll handle in the future. But yeah, from my experience as a financial advisor too, it's just having like those 3 topics, but, just everything documented to where then with family, not only the ease of then being able to handle those things, but just also the understanding of what your wishes are, right? So that, it avoids a lot of conflict with families, which unfortunately can definitely come from settling an estate, which I'm sure you've seen before.
Yes, absolutely. And, my wife thinks I'm nuts. Why would anybody want to be interested in working with death and taxes? But as Ben Franklin pointed out all those years ago, those are the things that are certain. So if they're out there and you can plan around them, it's a good idea to plan for them and to be able to say in advance. I think most people would if they stop to think about it. Well, if I couldn't take care of my kid, I'd really like to have a say in who's going to do it for me. And if I couldn't talk to the doctors, I'd like somebody to know what it was I wanted to say. And I'd like to be able to choose the person who's going to do that for me. So even though it's really not urgent in the moment, a lot of times you could think about an estate plan like an insurance policy. So if you bring your umbrella, maybe it won't rain. But if it does rain, you got that umbrella with you. And it's the same thing with the estate plan, that you hope you don't need it for a very long time, but it's there for you in case it's needed. It's the kind of thing where once you need it, it's too late to get it in place.
Sure. Yeah, well, why don't we step into then, like, the types of documents, right? So I know you have worded it as kind of a 3-step process: documents, funding the trust, leaving a map, not a mess. But, at least what you've referred to, I know, as kind of the big 4. Maybe you can just walk us through, what documents most people will have as part of their estate plan and what purpose they all serve.
Yeah, absolutely. Absolutely, Mike. And, I wanted to say to everyone watching, Mike and I have been preparing this for a while. This is I think really a kind of a special presentation for you, because most of the time what you find is that we talk about the structure of the estate plan. What are the documents that we need? How are they going to be set up? How do we arrange them in such a way to avoid taxes? And those are all really important pieces. But what ends up falling off the back end are the second two steps of the process that are also really important, that are the trust funding that Mike mentioned, which basically is making sure that you have the ownership set up properly for your assets, and that your beneficiary designations are correct as well. And then the last thing is what I call leave a map, not a mess, which Mike referred to. And the idea is, if you weren't around and somebody had to take over and manage things for you, how would they know what to do? And we're going to talk about that as well. So, the idea is it's not just about the documents, but people need to know, well, where are your documents? And what assets do you own? How do they have the ability to pay bills if you're not available? Do they have access to your usernames and passwords? Because at the end of the day, even if you set up an estate plan, they don't know where your documents are. They don't know what assets you own. They can't pay bills. They can't get access to your accounts. The whole thing comes down like a house of cards. So it's really important to pay attention to these last couple steps, which is the organizational part. And that's what I think is special about today's presentation, and we'll get to in a little bit later. But first, I wanted to point out to you, Mike was just asking, what are the big four? What are the big four documents that a person needs that are part of the estate plan? And the first one everybody knows is the will. So if we go back to what's the purpose of having an estate plan, and the estate plan's purpose is take care of kids, healthcare, and finances. First one is kids. And to appoint guardians for kids, what you do is you use your will to do that. So that's the first piece. And now everybody knows what a will does. A will says who gets our stuff when we're gone. The problem with only having a will is that you have to go through the court to move assets from a deceased person to the next person. So for example, let's say John Doe owned a house. He passed away. You look at the deed says John Doe. How are we supposed to transfer title of John Doe's house to a son? Even if he has a will that says my son, John Doe Jr., is going to inherit this house. Well, the truth is we have to go to court to get that to happen. Since we don't have access to John Doe's signature, what we need then is for the judge to stamp a court order that says, I hereby transfer John Doe's house from John Doe to John Doe Jr. Now that process used to take on average around a year. I've done a few in my day in about 8 months. I think theoretically it's possible to do one in 7 months, but I've never been able to do it. I hope at some point in my career. The last few months, the courts have actually been closed because of the pandemic. So all the hearings that we had set up were just canceled and rescheduled, and the new hearings are months and months out. So the 1 year and change that it used to take to get through the court, now it takes quite a bit longer, probably add on a few months to that. And also in terms of legal fees, let's say John Doe's house was worth $600,000, and the fees for probate to go through the court, they're based on the gross value of the asset. So it doesn't matter how much you owed. If you owed $500,000 to the bank, or you owed nothing to the bank, you owned the house free and clear. The fees when you go through probate are the same. And so, for example, on a $600,000 house, the legal fees would be a minimum of $15,000. Executor fee, minimum $15,000, another $1,000 goes to the court. So you're talking about over $30,000 in over a year dealing with paperwork at the court. And you can avoid that if you have a trust in place. So this is the lead into what's the second document, and that is a trust. And a trust is just an imaginary concept that the lawyers made up about 600 years ago. And to understand what it is, if you just think of a trust as a box that says the word trust on top, and you put your house and your cash and your stocks in that box, anything you put in that box is safe from probate. It never has to go to the probate court. And here's why. If John Doe owns the house, you look at the deed says John Doe, and he dies, we know there's no way to transfer it because we need John Doe's signature. But if John Doe sets up a trust, and think of it as that box, he moves his house into the trust box by changing the name on the house title from John Doe to John Doe Jr. Now John Doe, trustee of John Doe's trust. Now it's in the trust. And what that means is we don't need John Doe's signature anymore. We need the trustee's signature, whoever that happens to be on a given day. And the trust document will give us that list. And so if John Doe's not available, then the next trustee steps into his shoes, and they are the person who can transfer that house. We don't have to go to court. Mike, did you want to jump in before I get to the last two?
No, you're
Okay.
you're the expert. I was just letting you run with it, but yeah, I think the one important thing as you were going through that sometimes people get confused on is will is good and it is part of a will's important. It's part of an estate plan, but a will in and of itself does not avoid probate, right? It's and I'm gonna butcher it. I don't know the background of the word, probate, specifically, like whether it's Greek or Latin, but my understanding, is that probate is proving of the will, right? Is that's kind of where that word came from. Um,
That's exactly right. That's exactly
but
right.
so yeah, you'd still have to go through the courts, and so I guess this will get into the funding, but yeah, we'll get into like what goes into a trust, but yeah, I'm jumping ahead. But yeah, if you want to continue on with the other documents that are part of that big four, that'd be great.
Okay, excellent. Excellent. Yeah, and that's the point with the will. A lot of people think that if you have a will, you don't have to go to court. You have no probate. But you could really think of a will as your ticket to probate, because probate it's just a government service. If you haven't arranged for a way for your assets to move out of your name when you're no longer alive and into the next person's name, there's just no way to do it without a court order. And so the government has provided that service to us. It's just very time consuming and very expensive, and it's totally voluntary. You
Yeah.
can, with a little planning, avoid it.
Yeah, well,
So,
that's what I was going to say. Sometimes people, I mean, there's obviously the downfalls in it, and that's what we're talking about. But probate in and of itself is not a bad thing, right? I mean, it's just sometimes that's the only way to be able to then get assets from one person's name to another person's name. But when like you said, the cost associated with probate is what most people are trying to avoid, and that's where, like you said, setting up a trust can help avoid that.
yeah, it's interesting. Probate kind of, people think of it as a bad thing and they want to avoid it. And most of the time you do want to avoid it. In fact, when I first started doing this, I had clip art for part of my, back in the days of clip art, for part of my presentation in the meetings. And I had this, it was supposed to look like an evil witch's castle back then. But since then, Harry Potter's come along and people say, oh no, that looks like Hogwarts. That's
Yeah.
not scary at all. So, but in any event, sometimes probate is helpful. If you own a business and you've got a lot of different people who you owe money to, and it would be really helpful to have a structure in place, have a judge oversee it, and make sure that the right people are getting paid, that your heirs aren't being bullied by creditors, that kind of thing, then sure, probate has its place. But in the usual context where assets are being left to a spouse or to kids, especially in the case of minor kids, it really is to be avoided because of the amount of time and money that it takes. In the case of minor kids, you end up having to do an accounting to the court every year for what the kids own, until they're 18. And those things cost almost $500 each year just to file the petition and the accounting with the court to tell them what you've done. So, and that's not including the accountant's fees or the lawyer's fees. So it's expensive. And unless you really have a need for it, definitely to be avoided. So, but moving on to our next one. So we had the will, appointed guardian for kid. And in the context of a trust, the will just says, I leave everything in my trust. I meant to put everything in my trust while I was alive, but if I didn't do it, well, please do it for me now. And then the trust, I mentioned before, you just change the name from John Doe to John Doe trustee. And then the asset is considered to be in the trust. And the difference that makes is we don't need John Doe's signature. We need the trustee's signature. So that takes us then to the next thing, which is the power of attorney. And the power of attorney is designed to allow for management of assets that are not in the trust. So most of the things that you would own go in the trust, your real estate, businesses, bank accounts, brokerage accounts, but there are certain things, primarily tax favored assets, so IRAs and 401ks, these don't go in the trust for income tax purposes. So those are left outside the trust by design. And so you have a power of attorney to allow for management of those things in case of incapacity while you're alive. And there are other things that might have been left out of the trust by accident. So for example, let's say you bought a rental property and you forgot to put it in the trust. How would we get that in the trust for you if you were incapacitated? Well, again, we would use the power of attorney. Another thing you can do with the power of attorney is file someone's income taxes. Those obviously aren't part of the trust. So if you look at the trust and the will and the power of attorney as three documents that all allow for management of finances, the trust, anything that's in it, the trustee can manage for you during incapacity and after death. The will kicks in after death for anything that's outside the trust, and the power of attorney allows for management of anything outside the trust during incapacity. So the idea is, to the extent possible, to try to avoid the court. And if I can just make a pit stop here on trust and will, they both say who gets our stuff when we're not alive anymore. What's the difference between the two? We've kind of glossed over them, but just to list them out, you appoint a guardian in a will. You can't do that in a trust. The will says who gets your stuff after death, but it has to go through court. And the will also doesn't help you at all during incapacity. There's no way to manage assets through a will when someone's incapacitated. Whereas on the flip side, the trust never has to go to court, and it allows for management both if someone's incapacitated and after death. So, you know, in a complete estate plan, you really need both. You need that will as a backup to the trust to say, hey, put anything I forgot to put in my trust now that I've passed, you know, that I forgot to put it in there for me now. And also, if you have kids, you would need it for guardianship.
Sure.
And otherwise, I'm sorry, go ahead, Mike.
Oh, no, I was just going to say, and then, you know, I think, and I don't know if we would touch on it later, but, you know, cost, of course, is a big reason to avoid probate. But as you were talking there, you know, and getting the trust set up, you know, I think privacy, you know, is also a big thing for a lot of people, where you go through probate, you know, a lot of, you know, public information, public records, where obviously if you're handling it outside of the courts, then everything remains private.
Yeah, it's a really good point. And if you think about, you might think to yourself, well, I'd never go down to the probate court and look at somebody's records. And that's right. Normal people don't do that. The people who are down there looking through the records are the kind of people you don't want looking through your records. And especially if you own, you know, a business. I mentioned before, sometimes probate can be helpful for a business to help you manage all the creditors. But if you don't have that situation and you have a business that's being sold, all the financials are going to be down there at the court that anybody could look at. So to the extent that you want to keep these things private, and most people do, it's a really good point, Mike, that using a trust allows for keeping everything private, you know, only the people who you've named. So
yeah. And I think on the power of attorney too, how you had integrated that into, you know, certain things where there's incapacity and, you know, not being able to sign your name. You know, another example that I know I give is that, you know, like let's say with my wife and I, you know, if our only asset was, you know, my retirement account, you know, I've listed her as the beneficiary of my retirement account, but, you know, if I was in a coma or if I was incapacitated, you know, it'd be very difficult for her to gain access to that without, you know, having to go through the court system. Even though she's 100% beneficiary of that account, I'm still alive, you know, in that example. So, you know, other than her pulling the plug on me or going through the court system, you know, that's where, you know, the power of attorney can come in and allow her to be able to sign on documents like that to be able to gain access to funds that might be needed.
yeah, it's a really good point, because when most of us think about estate planning, we go right to a will. This is what we were all brought up learning about. And we also go right to, well, I'll live to 120, die peaceful in my sleep, and then people will get my assets. And I hope that's the case for everybody. But statistically these days, you know, like some of my older clients tell me, Adam, they won't let me die. You know, their bodies have given out on them, but the doctors are able to keep us around. And so statistically, we are a little bit more likely to have a period of incapacity these days than used to be the case. And so it's really important not to only plan for what happens when I'm not here anymore, but what happens if I'm still here, but I've lost my ability to manage things. I have dementia, for example.
Absolutely. Well, that then kind of brings us to healthcare directives, right?
Yes, that brings us directly to the healthcare directive. And, you know, in the old days, it was a living will and a power of attorney. The living will said, if I'm hooked up to life support, turn it off or don't turn it off. But it didn't tell you who was going to be in charge of making sure that happened. So you would also have a power of attorney for healthcare that said who would be in charge of doing these things for you. Since 2001, California has given us the Advanced Healthcare Directive, and it does both things. And this is one of the places where I wanted to, you know, step off a little bit to talk about the pandemic, because all of these things that we've talked about, the kids' healthcare and finances, they're important anyway. It's a little bit more important these days. I think, you know, the idea that it's not as urgent, maybe that's changed a little bit because we're being forced to consider that we might need an estate plan. But the healthcare directive in particular, a lot of people have fear of being intubated or being on a ventilator. And, you know, they go together. The intubation is the process of actually putting a tube into the windpipe. And then the ventilator or respirator, which is the same thing, is the machine that pushes oxygen down into your lungs once the pipe is there. And a lot of people have a fear about that. I'm guilty of it as well. It's something I would rather avoid. But a lot of people in their healthcare directive would say, don't intubate me. I don't want it. But I think that in the current context where we're finding out that this is a treatment that a lot of people are using, you might, if you have a healthcare directive and you've said no intubation, no ventilator, no respirator, you might want to go back and undo that in the context of COVID, because it could be the difference between still being here or not being here if they're not allowed to use that technique for you. So I just wanted to make sure I pointed that out. And also in the pandemic, the healthcare directive has become even more important, because in the old days, your family would be there with you and they would have a healthcare directive, so the doctor knew which person they could speak to and which person could make decisions for you. These days, you get dropped off at the curb and you are in the hospital by yourself because of social distancing and trying to stop the virus spread. So it's even more important to have that healthcare directive so that the doctors know who to call and who they can speak to, because there isn't anybody there to advocate for you except for you. So just another piece.
Sure, and it might be hard to answer this question, but I guess from your experience and working with clients over the years, I think in my state plan, I also have that language, right, of no ventilators. Would you say most people have that in there, and from your experience?
I wouldn't say that most people have it in there. It is a fairly common fear, and I've seen it in healthcare directives, but it's a small percentage of people who have that. And it would be something that you would add. It's not something that would be part of stock language in any healthcare directive that I've ever seen. Gotcha. However, because it's something that people do, I feel like people should at least bring it up, because people might have forgotten.
Sure. How would it work? I guess just a question I would have. Let's say, I guess it'd have to come out, a lot of hospitals, have healthcare directives that you can have just directly through the hospital. I think, you might want to consider making updates and changes to your healthcare directive that's part of your estate plan, but as a quick fix, I guess, if you will, for something, in the current environment and what we're dealing with COVID, regardless of what my typical healthcare directive as part of my estate plan says, would you say that the hospital healthcare directive trumps that, if you will?
Well, it depends. If you have two healthcare directives, you've signed both of them and neither of them revokes all the ones that came before it, then there's going to be a question there. It's like two competing documents that may say two different things, and people aren't going to know which one they are supposed to follow. And that's a good recipe for ending up back in court, because the doctors are going to say, we don't know which thing we're supposed to do. We're going to send it up to legal and we'll get back to you when they get back to us. That's exactly the position you don't want to be in. Sometimes you'll get a healthcare directive from the hospital, and I use the statutory form. I've updated it in small ways, but the doctors are used to seeing it. So we want them to be comfortable with it. And again, we want them to work with the person you've appointed. We don't want them to send that document to legal because they don't understand what it says. Sure. However, in the normal healthcare directive, you will not find a health privacy release. So HIPAA is the Health Insurance Portability and Accountability Act. Most of the docs I know refer to it as the Health Information Privacy Act. And every time you go see the doctor, you go to the hospital, they make you sign a privacy notice. The way that works in the context of an estate plan is the doctors need a release before they're allowed to speak to the person appointed in your healthcare directive, or before they're allowed to speak to your trustee or your executor, your power of attorney agent. So it's really important to have that. And most of the forms that you'll get from a hospital or from, we used to say, go to the stationery store. You could buy one of these. I guess you would go to Amazon now. They're not going to have a HIPAA release in there. And it's a really important piece to make sure that you've got this document and the doctor's not looking at it saying, I'm sorry, I can't talk to the person because I don't also have this HIPAA release.
Gotcha. That makes sense. And then we can move on. But one thing, because I know several people had joined us after we started, If anyone does have any questions, there's a chat feature. We'll probably not be able to get to every question, but if at any point during this, if anyone wants to type in any specific questions, we'll try to save some time at the end to get to those. And just on this topic, because I did see it and I just wanted to get some feedback, Adam, someone had asked the question about making a change like that. Is it something that, like, if I was to update my healthcare directive through, let's say my estate planning attorney, I could just specify, for COVID, that I'm okay with this, in a situation where it's related to COVID-19, otherwise no? Or do you feel like that might provide too much ambiguity on kind of the topic we were just talking about?
I think that's definitely something you could do. You could say for treatment for COVID, ventilator's fine, and otherwise it's not. Sometimes you'll find people who presumptively have COVID. They're not being tested. They're just hunkering down at home and trying to get better, trying not to go to the hospital. We don't know if they have it or they don't. But I think if you're in the hospital, they're going to test you to know one way or the other. So I think you could feel pretty safe that if that is the only context in which you would want to have that, you could say for COVID only, ventilator is fine. That's a good question.
Yeah, and I think just in general, that's the nice thing about having estate planning documents that, you have someone draft, but obviously you're kind of in charge of what it says. I know there's lots of areas that you can be very specific. We might not get too much into it, but how assets are distributed out to the kids or the nieces and nephews, what age, how much, I think that's one of the great things, not just avoiding probate and the cost, but being able to be very specific on what your wishes are.
Yeah, that's right. And I think it's another reason to have professional advice, because people come in with things and they'll say, okay, well, if I'm hooked up to life support, you can't turn it off for 30 days. I want to put that in there. And I say, okay, when does the 30 days start? Does it start from if you had an accident? Does it restart every time you're lucid? When does it start? Because you could end up fighting over that. And so some of these kind of things belong in the documents. Some of these kinds of things are better with a healthcare directive to talk to the people who you have appointed about what you would want in different circumstances, so that they have some idea what you wanted. Whereas once you put it in the document, it gives people a leg to stand on to fight about it. And they say, no, they said 30 days, but they didn't say 30 days from when. So,
Gotcha.
So yes, you can definitely put in lots of instructions. And I think it's great to be specific, but it's also good to have that professional advice to tell you which things belong in the document and which things should be part of a conversation, or even a letter that you leave. For example, you'll hear people talk about an ethical will that talks about you just leave it for your guardian that says, these are the things that are important to me for education for my child, or for religion, or for learning about finances, or the things that I want you to tell them when they start trying to figure out what job they'd like to do, or which college to go to, or before they go on their first date. Whatever things that you can think of. Very, very hard letter to write.
Sure.
But again, it's a place where you wouldn't put those things in your estate plan, but they go hand in hand if you have minor children.
Yeah, no, absolutely. So if we kind of jump, you had said, and it's true, right? It's important to get all the documents in place, so second step though is funding the trust, right? First of all, just remembering to fund the trust, I think is a big deal, regardless of what documents you get in place. But, I know there's certain topics, like you said, with types of accounts that end up in the trust, that don't end up in the trust, beneficiaries, et cetera. But maybe we jump into trust funding.
Yeah, very good. And this is a place where I think a lot of people, especially if they buy a trust from the internet, they get their trust, they sign it, they put it in a nice looking folder, put it in the drawer, and forget all about it. And then when it comes time to use the trust, they can't use it because nothing's actually been transferred into the trust. And for anybody who might have joined us a little late, transferring an asset in the trust is a simple process of changing the name, for example, on a bank account from John Doe to John Doe, trustee of John Doe's trust. Once it says it's in the name of the trustee of the trust, we don't need John Doe's signature anymore. We just need the signature of whoever happens to be trustee on a given day. And so the trust funding piece that we talk about is taking the assets. Now you've got your documents in place. What do you do now? You want to take those assets and move them into the trust. The ones that you don't want to do, there's a bright line distinction here: tax favored assets, IRAs, 401ks, those kind of assets don't go in the trust for tax purposes. But just about everything else, real estate, bank accounts, brokerage accounts, businesses, generally want to hold those in our trusts. And this is a place where it's really great to have a financial advisor like Mike working with you, because they're going to see you often and they're going to talk to you often, and they're going to see whether you actually put the assets in the trust or you did not. It's not actually that hard to do. It's just the kind of thing that most people don't want to do, to go to the bank and sit down and fill out some papers to transfer the account. It's not most people's idea of a fun afternoon, but it's really important to do. And if you think about what am I doing here? This really isn't benefiting me very much. We're volunteering for the benefit of the people who come after us. We are creating a legacy that we were a responsible person in our lives, and we didn't leave a mess for somebody else to clean up. And I see a lot of clients who come in and they say, the reason I'm here is because my uncle died. He made me executor. It was a horrible experience. It took forever. People fought. It cost a lot of money. I never want to do that to somebody else. And the thing is, it's really not that hard to avoid doing that to somebody else. You work with somebody, get an estate plan in place, takes a few weeks or a month. Then you work with your financial advisor and people at the bank to get your assets in the trust. And then you don't really have to think about it anymore. We mentioned before, death and taxes isn't so much fun to deal with, but if you associate to it long enough to get your estate plan in place, get your assets titled properly, then you don't have to think about it anymore. You know that it's handled. And that space in the back of your brain that bugs you and nudges you and says, hey, we got to do that estate plan one of these days, it'll be open for something probably more inspiring for you to do. So like Mike pointed out at the top of the section, it's trust funding step 2. I'm sorry, Mike, I interrupted you.
No, I was going to say, it just kind of reminds me, from my experience too, and, with like a lot of my clients being near retirement or in retirement, they're kind of at that stage where, they might be the trustee or the executor of, parents' trusts. And, after, I try to advise, all my clients, the types of documents that they need, but especially after you go through the experience, or if you know someone that went through the experience, even for a simple estate, having to go through the courts or handle that, it can be, pretty difficult. I've seen plenty of cases, and I'm sure you have too, where, all right, well, mom or dad or whoever, had a trust in place or had all the right documents, but, mom also kept track of everything in this little, black book. I'm thinking of a particular client a couple years ago where, the account numbers are listed. It's good that it was all in there, but it was, very cryptic and, hard to figure out. So it's, after you've gone through that, I think, and it's even more important, to get that in place for yourself. And one thing I just wanted to touch on it, and maybe we would cover this at a different point, but while I was thinking about it, is like how you had referred to as like, things that don't end up in the trust, tax favored assets, 401ks, retirement accounts, things like that. Just the way I've always thought about it, and correct me if I'm wrong, but is, the things that end up in the trust are the things that don't already have beneficiaries, right, associated with them. So like, 401k or an IRA has beneficiaries, life insurance has beneficiaries. So it already, if we kind of go back to the beginning of our talk of a way to just get something out of one person's name into another person's name, those already have that mechanism of transfer, right? There's beneficiaries designated. That's how it gets from me to my wife, or for me to, my 3 kids. Whereas like a house, doesn't necessarily have beneficiaries, other real estate, non-retirement brokerage accounts, large cash accounts, things like that. That's why you then need the trust, to be able to fund that or put those in.
Yeah, it's a pretty good rule of thumb with the beneficiaries. However, it doesn't apply in all instances. It might trip you up in a few places. So a couple of pieces. One is the fact that you have a beneficiary. So then you would say, okay, well, it doesn't go in the trust. You have to remember, we're not just talking about the death situation, but also the incapacity situation. So as long as you have a power of attorney that could manage the thing in case of incapacity, and it has a beneficiary, then the likely case is that we're not going to have trouble and have to go to court. But the other thing is things like life insurance that are not tax favored, you generally want to leave those into your trust. And here's why. So for example, let's say you left the life insurance to spouse, and spouse, you guys were in, I'm sorry, Mike, you guys were in this accident together, and spouse survives by 3 days. And then neither of you are around anymore. What happens to that life insurance now? She's survived long enough to be the owner of it, but she didn't have the chance to go and collect the funds. Now those funds are going to be in her estate, and we're going to have to go to probate. So in my opinion, much better to leave that life insurance to the trust. And then if spouse is alive and well, spouse uses those funds however he or she wants. If spouse is alive but unwell, successor trustee steps in and uses those funds for spouse's benefit and for the kids. So certain assets I try to avoid. I want those in the trust. It's the tax favored thing is really the bright line distinction. Another rule that I've been playing with is if it has an acronym or a number, it's probably not going in the trust. So 529 plans have tax favoredness, IRAs, 401ks. So it's another way to look at it. But really the true bright line distinction is tax favored. If there's some way you've already paid income tax and then it's going to grow and you'll never pay income tax, like a Roth IRA or a 529, that's tax favored. Or like an IRA, a regular one, or a 401k, you haven't paid income tax yet. You put it in, it's going to grow tax deferred and you'll pay income tax later. That's another one. Those are examples of what I mean when I say tax favored.
Okay, well that's why you're the expert now, and no, that's an important distinction. I mean, especially using that scenario as an example of where that might not be the case. So I appreciate that.
Well, I am sorry to have killed you too often in my pretend accident, though, Mike.
That's
Usually
okay.
I pretend
Well, you let her live a little longer. She's the better half anyway. So it's I'm totally okay with that.
Okay.
Anything else? I mean, because on ownership and title or beneficiaries, am I jumping ahead?
Yes. One last thing to point out. Whether you have a trust or not, the most common estate planning mistake that you'll find is beneficiary designations. And these are primarily going to be retirement accounts, life insurance accounts. So many times we think we designated someone and we didn't designate anybody, or we think we updated it and it's still the person from before. For example, I've seen this where it's the former spouse and the person is certain they've updated. They have not updated it. So this is something that's good to look at with your financial advisor or with the company who's holding these things. Get something in writing that shows who the actual beneficiary is, because you'd be surprised, as the years go by, how our minds play tricks on us. And this is the place where it happens. And there's pretty much no getting around it. After someone passes, that beneficiary designation usually is going to control.
Yeah, and just on that topic, I mean, I think there's been cases that have gone up to the Supreme Court, but regardless of what, at least my understanding, regardless of what your estate planning says, right? Whatever estate planning you put in place that says, like you had said with an ex-spouse, that, hey, everything I own goes to my current spouse. If that beneficiary designation says a prior spouse or someone else, my understanding is that beneficiary designation rules and will override any estate planning that you put in place.
Yeah, in general, if you look at what does a will control? The will controls only things that are in somebody's name, they've passed, and there's no way to move these things forward because it's, there's a beneficiary designation, or it was owned jointly, or it was in a trust. It's just John Doe's dead, his bank account is in his name, John Doe. That's the thing that is controlled by his will. If something has a beneficiary designation, beneficiary is going to control. It doesn't matter if you have a will or trust. If something's titled in your trust, John Doe, trustee of John Doe's trust, the trust controls. Doesn't matter if you have a will. And then finally, if you had something owned in jointly, for example, you owned a piece of real estate with your buddy, your best buddy, as joint tenants, even if you have a trust, even if you have a will that leaves everything to your spouse, that property is going to your best buddy because it's joint tenancy, and they call it by operation of law. The law says when the joint tenant dies, the surviving joint tenants own it. And so there's lots of different ways that things pass along. And what we try to look at is, given the context of the family, what their goals are, who they're trying to leave assets to, whether it's spouse or their minors involved, that we've set it up where we've looked at incapacity, we've looked at what happens after death, and everything's arranged where it's going to end up where it's supposed to be. And that's, one other thing I wanted to point out is, if you rely on beneficiary designations, every time you change your mind, you've got to go change every single account. Whereas anything that's actually in the trust, once you change the trust, you've changed it for everything that is in the trust. All the different accounts that are held in the trust, the beneficiaries will change just by changing the one document. So it's kind of a central place where you've got a lot of control.
Sure. And I don't, I know we've got some other things we want to make sure to hit, but just a question on beneficiaries, from someone that, may not be a long answer, but Is it change anything if the beneficiaries are non-U.S. Citizen or someone living in a different country when it comes to like the trust or retirement account as a beneficiary designation?
That is an excellent question, Mike, and it's got to be beyond the scope of today. We would have
Fair
to
enough.
do a whole a whole nother seminar for that. When you start crossing boundaries of countries, you want to look at where it's going. What are the rules in that country? Is there a way to set it up where the people on the other end would be taxed less than if you left it directly to them? And you want to look at the transfer costs that are going to be involved in the taxes once it goes from one country to another. And that depends highly on which country it is, if we have a treaty with them or not. So that's
just because I know it came up when we were working with a mutual client last week. The quick of it, I guess, is that yes, it does, right? Potentially have an effect, depending on what country and everything else. But it wouldn't work always exactly the same way as if everyone was just in the U.S. Is that a fair statement?
Yes. In other words, you can't assume that it's going to work in the exact same way as if you left something to your nephew who's here in San Diego. Things are different. Things are even different in different states. I mean, for example, New Jersey has an inheritance tax. If you live in New Jersey and you inherit from somebody, doesn't matter where, you're going to pay a tax to the state of New Jersey for the privilege, this is how they say it, for the privilege of receiving that inheritance. So you can't even really assume crossing state lines that things will be the same as they are here. So,
okay.
so it just,
countries take it to the next level, right?
Well, just you need to get professional advice about these things. In other words, don't assume.
Correct. Yeah, and I know certain questions, of course, are going to go beyond the scope here. What about so when you say, I mean, of course, getting all these documents in place and allowing people to know where those documents are, if we kind of jump ahead, to leaving a map and not a mess. When you say that, because I've heard you say that, plenty over the years. What do you mean by that, or what can people do to make sure to leave that map versus a mess?
It's a little bit elusive until you stop to think about. I mean, just imagine that you are a trustee for a friend. Your friend has passed. You've gone over to your friend's house. You walked in, and then you think to yourself, where do I start? What am I supposed to do? One of the first things that you need to do is find their estate planning documents. Do they have any? And if you find some, how can you be sure these are the most recent ones? Because people might do updates and keep them in different places. I've come to like using a binder for them. And in my early years, I would give people copies in the binder and then a set with the original signatures to keep somewhere safe. And what I found over time was that the original signature documents disappeared. And my clients would say, don't you have those? And I say, no, remember I gave them to you? I told you to put them somewhere safe. And they go, no, I don't remember. I don't know. I have no idea.
That's when you put something really safe, is when you don't know where it is. That's my excuse for a lot of things around the house.
Right. They hid them too well. And we all worry about fire and theft. In 20 years, I've had 0 burn. I've had 0 stolen. The only thing that's happened is my clients have lost their own documents. So having them in a binder seems to be really helpful. I have a blue binder I use, kind of like a boomerang. It always comes back with the clients, or if they've passed with their family, the binder seems to come back. So when we talk about leaving up, we talk about letting people know where your documents are. And then once they know where the documents are, the next thing they need to know is, what do you own? What am I supposed to be working with? Do you have a safe deposit box? Do you have life insurance? Do you have bank accounts? Do you have brokerage accounts? Do you have retirement accounts? Do you have stock options or RSUs from your company? I need to figure all these things out. It would be really nice if I had some breadcrumbs to follow. And so in the binder where I give people, it's pretty simple, really. The first tab is instructions. And then all the other tabs are the trust, will, power of attorney, healthcare directive. And then there's a tab for leave a map, not a mess. And behind that tab, there's some forms to fill out, like, do you have a safe deposit box? Did you do cord blood banking with your kids? Where are your important documents? Who are your advisors? And then they're supposed to 3-hole punch a statement from all the different accounts they have, bank accounts, brokerage accounts, life insurance, retirement, whatever it is. Because if your successor trustee knows where that binder is, they've got the binder, they've got the documents, and they've got the statements, they're up and running immediately. And that's what I mean by leaving a map. And if you take those statements, once a year, for example, at tax time, shred the old ones, stick new ones in there, they'll always have within a year, what was the bank? It was Wells Fargo. what kind of account was it? What was the account number? How much was in there as of last April or May? It gives them a really a big head start. And so, you know, when they talk about real estate, they always tell you location, 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 right? Well, the essence of an estate plan is organization, organization, organization. If you're organized and you leave these things for your successors, they will have a much easier time than if you're not. And there, you mentioned earlier about people, they helped with somebody's estate and it was a lot of work. There's, even with the trust, it's not a magic bullet. It reduces the amount of work you have by 80, 90%, but there is no getting out of this earth without leaving some paperwork behind. And what you can do is minimize the amount of work. You can minimize the time involved and the cost involved, and you can make it a lot easier for the people who have to do it. And it really doesn't take that much time. You set up your estate plan, the trust funding piece we talked about a little earlier. That's, you know, honestly, the part that people dislike the most. It takes a little bit of work. Tell people to do 1 or 2 a week, and then you'll be done. You never have to do it again. But the leave a map, not a mess really isn't that hard. You know, once a year to shove some statements in a binder could make a huge difference. And on that note, I wanted to point out one of the things that's new, hot topic in estate planning, is what they call digital assets, which really is just your usernames and passwords. How do you get access to the bank account and the brokerage account and so forth? Do you have the usernames and passwords? And if you have them, are you allowed to use them? Because there are pretty strict penalties for accessing someone's account when you don't have authority. So it's something that you want to see in the estate plan, that you've given your trustee and your executor the power to access these accounts, and you've given them the usernames and passwords. And there's different ways to pass those along. You know, some people will write them out by hand. Some people will use a program or a thing online like LastPass. You can have a thumb drive with a program on it. For example, e-wallet is one that you can use. I think it's about $30. You can keep it on a thumb drive, so it's not always on your computer, subject to anybody who might find your computer and try to hack into it. And if your trustee knows where the thumb drive is, they know the one password to get into your encrypted program, then they've got access to everything. One other piece to keep in mind there is you should probably put the installation file for whatever this program is on the thumb drive too, in case they don't have it. There was a case not too long ago. This guy did a beautiful job. His documents allowed access to his usernames and passwords. He left a list. They had the list, but his computer had viruses on it. And so nobody wanted to use the computer. They went to sign in, and all the company said, "We don't recognize this device. We do not recognize the device. Please answer these security questions." They knew some of them, they didn't know all of them.
You're right. So, or then they have to send it to the email that they might not have access to. It's like you said. I mean, it's I think when it comes to your trustee, it doesn't have to be like an attorney or somewhat like an accountant. It's just maybe you can kind of touch on that too. Is just somebody with that you trust, with a good head on their shoulders. And I think as maybe part of your answer too, like, do you recommend, I don't know if we've talked about this in a while, but like co-trustees, like I've got 3 children. Let's say that this is a long time from now, they're all, adults, they're all responsible. Sometimes you don't want to pick a favorite. Would you recommend having them all as co-trustees or having them listed individually?
I say pick a favorite, Mike. Sorry, but you got to pick a favorite. The litigators will tell you it's just one in the pile among many, but it is one factor that leads to litigation is having co-trustees. Another problem with co-trustees, in my opinion, is if more than one person's in charge, no one's in charge. We want somebody, the buck stops here, a leader. And also, one thing that most people wouldn't realize is if you set up your trust with your spouse and your co-trustees and you go down to the bank and you get a bank account, all day long, they'll give you a bank account as co-trustees. But if you are a successor co-trustee, so mom and dad have passed and you and your sibling go down to the bank and you want to get on that bank account, they're going to give you a hard time. Most of the banks don't like successor co-trustees unless those co-trustees are free to do anything they want, irrespective of whether the other one knows about it. And that's kind of problematic. We used to set it up where we would say, well, you can be co-trustees, and you can delegate to each other, but we're not going to do any of that. You have to work together unless you delegate to each other. And so then they'd come into the office and we'd sit down and we basically make an agreement. You do this, Mike, I'll do that. Neither of us will spend over whatever number we come up with, $1,000 without telling the other person. And that's how we would do it. Now we have to do the flip if you have co-trustees, where we say, do anything you want, so we can get a bank account. And then I try to drag them into the office to say, can you agree that you won't do anything without telling the other person?
Sure.
It's really not a good spot to be in. So I highly recommend having one person. The other people can help with anything that person delegates to them, but it's really important to have one person in charge, in my opinion.
And I think too, I kind of figured that'd be the answer to the question, but just, yeah, administratively, if one of my, children are here in San Diego and one, lives in New York and one lives overseas, it's just, yeah, very difficult, to just get everything signed. And, for the most part, like you said, it's good to work as a team, but your document or your wishes are documented right within your trust. So that one, let's say if I picked one of my children, they're not necessarily saying, okay, well, you know what, mom and dad really like me more, so I'm going to get 2/3, or I'm going to get most of the estate, where they're just going to leave you a little more. It's just them carrying out your wishes, right?
That's true. They do have to follow what the trust says, and let's say there are 3 kids and it's an equal split, so everybody's going to get 1/3. Yeah, ultimately everybody will get 1/3. Well, the trouble starts, in my opinion, where the trustees don't keep their siblings in the loop about what's going on. So I always advise my trustees, you need to bore your siblings to tears with everything you're doing, all the phone calls you made, all the horrible things you did, so that their thought, instead of, what's he doing? Why is it taking so long? Where's my money? They think, wow, I'm glad I didn't have to do that. Thanks for doing that.
Yeah, I've definitely seen that.
Yeah, you almost never hear someone say, wow, thanks for being trustee. I bet that was really horrible. I appreciate you doing that for me. They should say it. They're not going to say it.
Yeah, it's well, I know we're coming up to the end, and I guess the one thing I'm going to post real quick, and then see if you had any like final thoughts, Adam, or anything else to be aware of. But we've been doing a lot more of these webcasts over the last few months, and want to continue to improve upon them. So I know some of you, like the question on foreign beneficiaries, might have some follow-up questions. I know there's some other questions we really didn't have time to get to, but for everyone, I'm going to post, I guess I'll just do it right now, but we have an evaluation form. So if you see it pop up on that chat, it's just canterwealth.com/evaluation. I believe you'll also probably get a follow-up email that'll just include that evaluation. But, any feedback, would definitely be appreciated, just on, structure, or, even just, other topics, right? We've had several past webinars, which you can also find on our website, on life insurance and long-term care, Medicare, managing your assets, through a pandemic like this. But we want to, continue to hold them. So if there's any topics that you think would be timely, or anything that you think a lot of people would get benefit from, feel free to put that on the evaluation form. But also, if you have any questions, of course, I know there's a combination of existing clients, of Canter Wealth on the line, as well as those that aren't clients. So, if you have any questions, and of course, if you're a client, feel free, reach out to myself or, your advisor. But then also, if you're not a client of Canter Wealth, part of that evaluation form also includes a free compliment or a complimentary financial checkup. So, like I mentioned at the beginning, we try to look at integrating every part of someone's financial life. And unfortunately, sometimes we can have a discussion on estate planning, or we can have a discussion on Roth conversions or tax planning. And it's really difficult because you're having a discussion on one specific topic, but you really need to see how that all comes together. So, again, if you're not a client and you want to, take us up on that free checkup to look at, are you on track? Are you already retired? Are you on your way to retirement? What tax planning makes sense? If it's, if there's certain things with your estate plan, you could, I could bring in Adam and we could, get certain questions answered, or if you just have specific questions that you want to include on that evaluation form, feel free to put those in there as well. And, I can reach out to you, another advisor at the firm, or, if it's something where we need Adam, we can, get his feedback as well. But if everyone could fill out that evaluation form, that would be really helpful. Just, again, get good feedback on what we're doing. But Adam, I appreciate it. I don't know. I know we covered a lot, and it's really hard to cover everything just within an hour, but any other pointers or anything people should be aware of, now during the pandemic, or just in general with regard to their estate plan? Or I guess, I don't know, what do they say, like final thoughts?
Final thoughts. Just to take this piece we were talking about at the end, the leave a map, not a mess piece, and just give it some consideration. Think about all of the things that you do to run your own financial life. I just give you an example. We had a credit card expire, and I had to call all these different places and give them the new expiration date. It took forever, and I was thinking, wow, what if it was a trustee, someone else who did that for me? Would they know which places to call? Would they even know to call? How big of a job would that be? It's just anything that you do with your financial life. When you set up your estate plan and when you leave the map, the point is to try to think of those things and try to make arrangements so that the person who steps into your shoes is best positioned to be able to do them with the least amount of hassle and the least amount of time. So they are, giving of themselves for us, for our benefit. They're helping us by doing this. So I think it's showing them respect to do the same in advance to try to make that job easier for them. And I want to thank you, Mike, for the opportunity to be here, and thank everybody for coming out, being part of people's estate plan. I see it as a very honored and privileged to be at the table with people for these very personal, very important matters. So thanks everyone for your time. And Mike, I'll go on the evaluation and give us both really good marks for our presentation today.
Yeah, no, no, I appreciate that. And yeah, I mean, it's always been a pleasure working with you and clients. And I know this is always, obviously really sensitive information. So there was a slide, I know I kind of bounced back and forth, with, wanted to make it interactive with Adam. But, if anyone, again, wants to reach out to myself, put it on the evaluation form, reach out to one of the other advisors if you're working with, them. We can always get you in contact with Adam if you don't have estate planning documents in place, or if you're looking at restating all of your estate planning documents, if your wishes have changed, or if the attorney you haven't, that you originally worked with isn't around, retired, passed away, happy to get you in contact with Adam. But yeah, I appreciate you being here, and hope everyone got some good information out of today's webcast. But yeah, if you could give us some feedback on that evaluation form, it would be super helpful, and what other topics you want to see. But other than that, yeah, thanks for your time, Adam, and I hope everyone has a great rest of your day. Take care.